participants from all over the world, including universities such as NLS Bangalore, University of Oxford, National University of Singapore, etc. While we are called the Moot Court Society, it is a little bit of a misnomer. We do not just look at moot courts. We also look at a wide variety of competitions. We look at arbitration moots. We help students and we administer negotiation competitions, mediation competitions, client counseling competitions, and trial advocacies. Basically anything and everything under the sun related, even remotely related to the practical application of legal skills. And well, the Moot Court Society is going to be your best bet. We are a society with restricted membership. There are two ways in which the students of CLC can gain membership of the society. One of them is as first years, they can participate in what is known as the Freshers Induction Moot. And if they qualify through the Freshers Induction Moot, then they can be part of this society, be members of the society through that. And then we also have the Common Induction Moot, which happens typically at the beginning of the academic year, which meant that for this academic year, it happened in September, October. That is open to students of all three batches. Due to the incongruence in schedules, we understand that first year students regrettably did not have the option of participating in what we call the CIM, but you will have the opportunity to participate in the FIM and qualify for the membership of the society this year. And otherwise, as second year and third year students in the later years, you can try your luck as through the Common Induction Moot. Once you have become a member of the society, you do not have to go through the induction process every year. Once a member, well, always a member. There are certain privileges that come with being a member of the society. That is, you get exclusive access to competitions that we receive invitations to. We open about 120 to 140 competitions in an annual year. That is at least the aim. And it is the members of the society that have the right to participate in that. We also open competitions on a fairly regular basis for non-MCS members. But of course, there are certain privileges to members that, because of which we would urge that you do give your best shot when the induction moots come around. Given that we are going to be in a virtual setting for the time being, we would there are multiple ways in which you can follow the Moot Court Society and its activities. The best and the safest bet is our Facebook page, which is the link for which Prerna will share, just shortly share on the chat box. And otherwise, we have our Instagram handle and as well as a LinkedIn handle, through which you can receive updates about the activities, notices, anything that we are hosting for the students of CLC or any workshop or anything that we are doing. We make sure that we publicize that well in advance through our social media handles. Besides that, we have a WhatsApp group, but that is exclusively for members of the society. And of course, you can always follow the notification sections on the CLC website. Typically, important announcements of the Moot Court Society, whilst being shared on our social media handles, are also shared on the CLC website. With that, I would like to give a warm welcome as well as a brief introduction to our teacher members. So for that, I will start with Dr. Harleen Kaur. Ma'am is the teacher convener of the Moot Court Society, and under her able guidance, we've had a fantastic 1.5 years so far, and looking forward to a fantastic 6-7 more months ahead. Very warm welcome, ma'am.
Thank you so much, Madhav. In fact, I am blessed with having exceptionally talented and dedicated team of students. Thank you so much, everyone.
Thank you, ma'am. Thank you so much, ma'am. Assisting Harleen ma'am is Neha Aneja ma'am. I would request Neha ma'am to kindly turn on her camera for the benefit of the first year students.
It is already on.
Thank you, ma'am. Along with her ma'am, we have Rubina ma'am also.
Yes, good evening, everyone.
Good evening, ma'am. Then we have Apanjot ma'am. 𝐿𝐻𝐲𝐻𝐿 sir. Cholaraja sir. Mahapara ma'am. And Suman ma'am.
Good evening, everyone.
Thank you, teachers. So as you can see, it is a team of 8 teachers who have been entrusted with the responsibility of leading the society. Assisting the 8 teachers in that regard is a 14-member executive committee. I, Madhav Goel, I'm a third-year student, and I'm the student convener of the executive committee. Helping me discharge these roles is Shaurya Gupta, who is the senior executive member of the Moot Court Society. Shaurya. There seems to be some connectivity issues on his end. Then we have Nitesh. I think Nitesh is already here. So Nitesh,
Oh, yes. Good evening, everyone. Hi, I'm Nitesh.
then we have Rushika.
Hi, everyone.
Along with Rushika, we have 2 more third-year members. That is Keshav Sharma. Keshav, we request you to switch on your camera.
Hello, everyone.
And the final third-year member is Ayushka Sharma.
Good evening, everyone.
Assisting the third years is a team of 8 second-year members. So we have Prakriti. We have Ajat Shatru.
Hi, good evening. Have a good.
We have Uday.
Hi, everyone.
We have Dropta.
Hi, everyone.
We have Ashish.
Hello, everyone.
Prerna.
Hi, everyone.
Pooja.
Hi, and good evening, everybody.
And Ayush.
Hi, folks.
Hello. Thank you, everyone. After following the introduction, I would like to welcome Apanjot ma'am to give the welcome address.
Thank you, Madhav. A very good evening to all of you, respected Dr. Harleen Kaur ma'am, convener MCS, teacher members, student members of the MCS committee, and my dear first-year students. I also extend my heartfelt welcome to Yash and Harshita for accepting our invitation to judge the demo moot. It is a pleasure to welcome you all to the orientation program of the Moot Court Society. Campus Law Center has a very vibrant and active mooting culture where both the teachers and the students work hand in hand for planning, training, and executing mooting activities. There is no better way of providing a hands-on skill training to the students. It is here where you actually learn to practically apply the theoretical knowledge that you learn in the classrooms. So when you participate in the Moot Court competition, it gives you a glimpse, of the actual reality that you would actually face after the college, but it gives you a glimpse before the college itself. So basically what it does is, when you participate in the Moot Court competitions, it improves research and writing skills. It builds your confidence. It makes you understand how to work, in a team. It improves your practical knowledge and also helps you to build your networking. So basically, it leads to an all-round development and a holistic development of the students. So the ultimate aim of the society is actually to create a strong tradition of successful mooting for years to come. The MCS, under the aegis of the PIC, has organized several Moot Court competitions. It annually hosts the prestigious 𝐾𝐾 Memorial Moot Court competition in the campus. And internally, as Madhav just told you, we organize the common induction moot, which is open to all the students, and freshers induction moot, which is open to the first-year students. So I would actually encourage all of you, to be a part of the MCS family and take the society to another level. Over to you, Madhav. That's all I wanted to say. And thank you all for coming and joining us here.
Thank you, ma'am. With that, I would like to invite Harshita and Yash. They are our seniors from the batch of 2020. Harshita is a past student convener of the Moot Court Society, and Yash was a senior member of the Moot Court Society himself. They are going to be the 2 judges. So welcome Harshita, welcome Yash. We are grateful to have you here and looking forward to a fantastic demonstration. I would also like to invite Ayush and Ajat, as well as Ashish and Prakriti to proceed with the with the Moot Court demonstration. In case students are curious about which problem they are going to be arguing around, the same is available on our Facebook page. I think today in the afternoon it was posted. In case you haven't had a chance to, it's a very short problem. You can go through that. It's a simple problem on contract law with essentially three major issues. That is time being essence of the contract, damages, and force majeure. With that, I would like to invite the judges as well as the speakers to proceed with the Moot Court demonstration.
Well, hello everyone. Thank you, Madhav, for inviting us, me and Harshita. It was a pleasure to be back in CLC after at least 2 years, after an abrupt ending because of the COVID. So thank you so much.
Your Honors, good evening. This is counsel number 1 for the plaintiff. May I start with the arguments with your permission?
I would like to see my co-judge Harshita over here.
Sure.
Harshita, can you hear us? Madhav, can you please look into it?
I'm doing just that. Just give me a second. My apologies for the delay. We're just trying to reach Harshita. I'd just request everyone to be a little patient. Thank you.
I think Harshita joined, but she left. So meanwhile, Ayush, you guys can coordinate with Harshita, and you can, acquaint students with the induction process more before we can start with the arguments before the Yash. It is good, so good to see you, Yash. Thank you so much for joining us.
My pleasure. Thank you so much.
Thank you.
Ma'am, I just got in touch with Harshita. She's just, I think there were some internet issues on her end. So she's just.
Who was there in the meeting also? Yeah. Meanwhile, I was just telling Madhav, till the time she joins us, I mean, in case she's taking time. So in case you want to acquaint students with the induction process, you can do so.
Ma'am, I think 1 minute lagega, and we'll then do it in one comprehensive go. She's just waiting, ma'am.
Madhav, I think we need to make some space for Harshita. She's not able to get in the meeting.
So we have space for 6 people now. If you could just request her to try again.
Sure thing.
Yes, I think Harshita has been able to join. I think some internet issues on her end.
Yes.
But anyway,
So sorry.
no worries. So anyway, as I was saying, we welcome both Yash and Harshita to be the judges for today. And with that, we leave it to the discretion of the judges to for the moot court demonstration.
Thank you.
Shall we, Harshita?
Yes, please.
Ayush, you may.
Thank you, Aman. Good evening, Your Honors. This is counsel number 1 for the plaintiff, Mr. Ronald. Is the counsel audible and visible, Your Honors?
Yeah.
Very well. You're audible and visible.
Much obliged, Your Honors. Your Honors, allow me to present a brief summary of the factual scenario of this case.
Sure, go on.
Your Honors, Mr. Ronald, my client owns Hogsmeade Garden's most exquisite wedding parlor by the name of Hogwarts Garden. Hogwarts Garden renovation was contracted out to the defendant, Malfoy Constructions and Innovations Limited. This company's CEO is Mr. Donald, who happens to be a good friend of Mr. Donald and was in continuous communication with him. Your Honors, Mr. 𝐒𝐫𝐴 had been informed about a booking regarding a wedding that was supposed to take place in July 2020. And he had confirmed that the renovation of the wedding parlor would be complete by September 2020, leaving ample time for Mr. Donald to make other arrangements and make sure that the marriage in November takes place in the proper format.
Counsel, I would be interrupting you.
Yes,
Just
yes,
tell me
Your
the gist of the facts. Just tell me the main gist of the facts. What was
Yes,
the
Your
main
Honor.
contention? What is the issue?
Yes, Your Honor. Your Honor, the main contention is that the contract of renovation that was entered into between Mr. Ronald and the company Malfoy Innovations Limited, time was of the essence of this contract, and the contract was not fulfilled by the company, the defendant Malfoy Renovations and Constructions Limited. It was due to certain issues that they have presented and they might argue. But our strong case is that there was no material change in circumstances of any sort, and this contract was not adhered to, which has led to losses for our client, Mr. Ronald, in the consumer court to the tune of £14,000. And other than that, there has been loss of goodwill and loss of business due to the same. And this is why we have approached this honorable court to seek remedy for the same.
Okay.
So, Your Honor, if you are satisfied with the statement of jurisdiction in the memorial, may I proceed with the arguments?
No, please give me a justification for arriving to this court.
Yes, Your Honor. Your Honor, we have arrived in this court under the section 15 of the Civil Procedure Code, which says that every suit shall be instituted in the court of the lowest grade competent to try it. Now, Your Honor, we are having this read with the subsection 2 of section 5 of the Delhi High Court Act 2015. This was amended recently, and a notification published in the Delhi Gazette dated 4 July 2018 regarding the pecuniary jurisdiction of the commercial courts at district level. And this notification, Your Honor, specifies that the pecuniary value of the commercial court at district level shall be above 3 lakh rupees and not more than 2 crore rupees. Your Honors, we are seeking the remedy that we are seeking, if converted into rupees, comes within this jurisdiction, and that this is why we have approached this honorable court.
Okay.
Okay.
Your Honor, may I proceed with the arguments?
You may.
Your Honor, as I said, that Hogsmeade Garden's most exquisite wedding parlor, Hogwarts Garden, is a place which celebrates the values of the people of Britannia, and these values are of having good relationships and celebrating moments of life and occasions of life with joy. Your Lordships, the renovation which was not completed on time has led to losses for Hogwarts Garden and has also led to loss of significant goodwill. My co-counsel and I will be presenting this to you in a three-pronged argument. This three-pronged argument would contain: 1, that the time was of the essence of the contract; 2, that there was breach of contract by the defendant; and 3, that the plaintiff deserves to claim damages for the losses due to the breach. Now, Your Honors, I would be arguing the first prong of the argument, that is time was of the essence of the contract. And after that, my co-counsel will be taking you forward with the other two arguments. Now, Your Honors, as far as the first argument is concerned regarding time being of the essence, before we get into the hardcore arguments, I would request you to remember three things: intention, commerce, and extension. For the sake of clarity and erring on the side of repetition, I would repeat: intention, commerce, and extension. Now, Your Honors, time is of the essence of the contract is a concept that is found in Section 55 of the Indian Contract Act, which is pari material to the laws that are there in Britannia. Now, Section 55 of the Contract Act, essentially, if I go into the gist...
I hope that you make us remember these points through your arguments. The bench would like that.
I will, Your Honor. So, Your Honor, as far as Section 55 of the Indian Contract Act is concerned, it states out that if the party's intention was to make the time the essence of the contract, time is of the essence. This is the gist of the section. Now, Your Honors, which is why I put out intention part to you. Now, as held in Hitkari Motors versus Athar Singh AIR 1962, the question whether time is of the essence of a contract is a question of fact. Now, since it is a question of fact,
on the memo?
Yes, you will find this on page number page number 9 of the memorial. Do you want me to guide your Honor to the paragraph also? Okay.
It's okay.
Much obliged, Your Honor. So, Your Honor, as I said, that in this case it was held that is a question of fact. Now, considering our given factual scenario,
before you proceed, what were the facts of this case?
Your Honor, as far as Hitkari Motors versus Athar Singh is concerned, if Your Honor would give me some time, I would look at the facts and get back to you after my co-counsel's arguments. I do not have them handy right now.
No, but how do you say then they are applicable if you've not even looked at the facts? You know, it could be distinguished on facts itself.
Yes, Your Honor. I have looked at the facts, but I do not have them privy with me right now. If you could give me that extension, or my co-counsel can do that while I submit this point, Your Honor.
All right.
Thank you, Your Honor. So, Your Honor, in our given factual scenario, the contract clearly stated that the renovation was to be completed in reasonable time, and that Mr. Draco later confirmed that after being informed of the marriage, this would be completed by September 2020, which is a time frame that was specifically fixed according to the November marriage. This points out to the fact that there was intention to create a contract where time was of the essence because the marriage was coming over. Now, this extension can also be found in para 6 of the Moot proposition, and we have also mentioned this in our
Is it possible that can me and my co-judge get a list of the entire events? Like the way you are presenting it, I am not able to understand what is happening when. I want a small gist of the entire time.
Your Honor, I will do that. Do you want me to give you a monthly gist of the facts?
Do anything which helps you in the case.
Okay. Your Honor, first of all, in June 2020, there is certain Mr. Harry who approaches Mr. Ronald for booking the Hogwarts Garden. Mr. Ronald is our plaintiff, who is the owner of Hogwarts Garden. Mr. Harry is a client. Now, after this happens, in July 2020, Mr. Ronald informs the defendant company, Malfoy Construction, and their CEO, that there is a marriage that is supposed to take part in November 2020. Now, in July 2020, the defendant confirms that the renovation will be completed by September 2020, therefore leaving a lot of time for the November 2020 marriage. Now, this is what has happened after that. In September 2020, when the plaintiff approaches the defendant regarding the renovation work, the defendant says that they need a 20-day extension and they will complete the work. This is granted by the plaintiff because of the values that Britannia upholds, but this is also not adhered to by the defendant. And ultimately, on November 3, which is 2 days before the marriage, the renovation is not completed, even after the plaintiff has done a lot of efforts for getting this done by a third party, because the defendant was not able to do that. Now, even after that, Your Honors, the renovation was not completed and it led to the loss of business and a loss of £14,000 in the consumer court by the client. This is the monthly factual basis of the problem. May I proceed, Your Honor?
Yeah.
Yes, Your Honor. So, as far as I was talking about the intention part, now I would just quickly come to the commercial aspect of it. Now, Your Honor, there is another case of the federal court, of the Supreme Court, which is China Cotton Exporters versus Biharilal Ramcharan Cotton Mills Limited. This is a case of 1961, in which it was said that in commercial contracts, time is ordinarily of the essence. Now, Your Honors, you will see that this is a place of commerce.
Also, please keep mentioning the cases if they're mentioned in the memo. It's very difficult to follow them. Please keep mentioning all the cases.
All right, Your Honor. Your Honor, this is also mentioned in the memorial. And in this case, also, it was held that if it is a commercial contract, it is normally assumed that it was a contract where time was of the essence. Now, this is a commercial entity, Your Honors, where the marriage was supposed to take place in a certain amount of time and the money was paid, the consideration was paid. This points out to the fact that this was also a commercial contract. And this also would lead the court to believe that in this commercial contract, time was of the essence. Now, thirdly, as far as extension part of the same is concerned, Your Lordships, another case that you will find in the memorial is the Budhrachan.
So you are saying that this was a contractual agreement of renovating the entire wedding place.
Yes, Your Honor.
But as per the annexure A given, it says the agreement was to complete the entire commercial setup within this 1 year's duration. It doesn't mention the marriage.
Your Honor, the marriage contract was between other parties. The contract that is presented in the annexure is between the defendant and the plaintiff of renovating the marriage parlor, and the marriage parlor had been rented out for a marriage in November, which could not be fulfilled because the renovation went on till November, and therefore we are claiming damages.
So there was a contractual agreement between you and the defendant?
Yes, Your Lordship.
Can you present me the annexure?
If you go to, Your Honor, can I seek a 2-minute extension?
Harshita, can be?
Thank you. Let's give him 2 minutes.
Sure, go on.
Allow me to point you to Annexure A, where you will find the renovation agreement between the plaintiff and the defendant.
That I know of already. Counsel, I'm asking you, where's a contractual agreement for the marriage happening?
Your Honor, that is not presented in the moot proposition, I'm afraid.
Okay, move on and wind up quickly.
Yes, Your Honor. Your Honor, finally, as far as the extension part is concerned, as I pointed out, that an extension was asked for in September, which was granted. Now, in the case of Budhrachan versus Betts that you will also find in the memorial, it was held, and I quote this from the court, from the case itself, that this conclusion is confirmed by the circumstance that the defendant obtained an extension of the time. If the time were not of the essence of the contract, he need not have asked for an extension of time. So, Your Honor, as we see in these facts, the extension was sought, and the extension was sought because it was understood between the parties that time was of the essence of this contract. And
Counsel, do we have any judgment? Do we have any judgment of the honorable courts pari materia to the Court of Britannia or Hogsmeade? The case mentioned here is of West Bengal, if I'm not wrong.
Yes.
We have any of the cases related to Britannia or Hogsmeade?
Your Honor, the cases that I am citing are in pari materia to the cases. The laws of Britannia are in pari materia to the cases that are there in the Indian courts. So, which is why these cases have been cited.
Okay, I'll just clarify my point once more. Can we have any case from the Supreme Court of India or from Delhi High Court?
Your Honor, I will try to get back to this by the end of the arguments of my co-counsel.
So you have two things to get back to us. Move on.
Yes, Your Honor. Your Honor, these were the three cases that the three arguments that I had for timing of the essence of the contract. And with this, I would like to yield the floor to my co-counsel.
Sure. Go on.
Good evening, my lords. If I'm audible and visible, may I please begin with my submissions?
Yes, please.
Thank you, my lords. I'm grateful. I'll start by addressing the meat of the matter. That is, whether COVID-19 could be treated as a force majeure event in the present case or not. I think the heart of this case lies within this particular issue, my lords. My lords, I'll begin by explaining to my lords as to what constitutes force majeure, right? My lords, Section 56 of the Indian Contract Act incorporates the concept of force majeure within the laws that are followed by the state of Britannia, my lords. My lords, Section 56, I'll just briefly take over, my lords, through this section, even though my lords have vast experience. My lords, a contract to do an act after the contract is made becomes impossible, or by reason of some event which the promisor could not prevent, unlawful becomes void when the act becomes impossible and unlawful. My lords, it means an event or effect that can be neither anticipated nor controlled. Those events are events that whose performance is excused by the law. My lords, it is with reference to all circumstances independent of the will of the man and which is not in his power or control, my lords. My lords, therefore, the test of determining whether an event is force majeure or not is twofold. Whether it was impossible to perform that particular act, and number two, whether it could have been controlled by the person who...
Counsel, you have all the time. Go a bit slow. You have all the time. Don't worry.
My apologies, Your Lordship. I will definitely go slower. What's the second test is whether it could have been controlled or not. My lords, I'll start by quoting certain authorities which will demystify the position of law on this particular aspect, my lords. My lords, the first judgment that I place reliance on is the judgment of 𝐸𝐵𝐵 Ghosh versus Mudimannan, which is a Supreme Court judgment back in the 90s, my lords. My lords, and this is considered to be the locus classicus on section 56. In this case, my lords, the court said and held that the court can proceed to grant relief on the ground of subsequent impossibility only when the very foundation of the contract becomes upset by the happening of an unforeseen event, which was not anticipated by the parties.
Counsel, but your co-counsel has not shown me the contract piece where you have asked the defendant for the hall to be built before the marriage is commenced.
Right. My lords, if my lords peruse the annexure A, my lords, if my lords may have annexure, just give me a second, my lords. I'll just quickly... Right. My lords, if my lords have annexure A, point 2 of annexure A categorically says that the contractor shall commence the renovation project on or before the 5th day of January of 2020 and shall finish the work within a reasonable time period. And reasonable is a key word here, my lords, to be ascertained jointly by the owner and the contractor. My lords, I concede that there is no specific clause which says that it should be done before the marriage.
Please read the last line as well.
And in any case, before the 5th day of January of 2021. My lords, in a scenario where they have jointly ascertained a particular date, 5th day of January 2021 doesn't kick in. 5th day of January 2021 doesn't only kicks in when there's no date which has been ascertained jointly by the defendant and plaintiff, which is not the case here. In the present case, routinely by communication, which is multiple times when my client communicated with Mr. Malfoy, Mr. Malfoy gave repeated assurances every now and then, my lords. And my lords, the date was he himself on many accounts claimed that the work will be before the marriage takes place. If my lords have...
Where are all these claims being made?
Right, my lords. I'll just take my lords to that, my lords. Just allow me. My lords, para 7, my lords. If my lords may have para 7 of the Moot Court Compromise, the last line says, he was reassured of it being completed well before the wedding day, my lords. My lords, this in itself indicates to my lords that both of them had an common understanding, wherein they knew that the work had to be completed before the day of marriage, my lords.
Are you referring to annexure B for this?
Para 7 of the Moot Court Compromise, my lords, not annexure B.
Your para 7 comes in from annexure B itself?
My lords, it might not come from annexure B, but it is part of the facts that have ensued, my lords. And since annexure B maintains that, the time can be jointly determined, this is what depicts that joint determination of time, my lords.
Isn't annexure B a private conversation?
My lords, it may be a private conversation, ma'am, my lords, but it is also admissible in terms of it being a communication between the plaintiff and the defendant, my lords. In a contract, right, my lords. My lords, if I may proceed, if your permission.
Sure.
Sure, my lords. My lords, having said that, my lords, I'll just quickly rely on another case, which is the most recent judgment of the Supreme Court, which also reiterated 𝐸𝐵𝐵 Ghosh. And this is a judgment of, in the case of Energy Watchdog versus Central Electricity Regulatory Commission and others, wherein, my lords, Justice Nariman in no uncertain terms held that a contract is not frustrated merely because the circumstances in which it was made are altered. The courts have no general power to absolve a party from the performance of its part of the contract merely because its performance has become onerous on account of an unforeseen turn of events. And my lords, here is where I'll just get into a bit of explanation, my lords. My lords, in the present case also, if my lords peruse the facts, my lords will know that the conditions at best became onerous because the workers went on a strike. COVID came upon the company. The company was already suffering from financial losses and did not have enough money to pay the workers. All of that, my lords, is a part of the conditions becoming onerous, my lords. At no point in time can these conditions be construed to make the contracts performance impossible, my lords. And therefore, my lords, this case is pretty similar to any case wherein the courts have held that mere commercial impossibility or commercial difficulty, my lords, I apologize, not commercial impossibility, mere commercial difficulty is not akin to the conditions becoming impossible to form the contract, my lords. My lords, with that, my lords,
I'm pretty sure COVID-19 in itself was a big effect to hamper the entire working of the.
Right, my lords. My lords, so in the present case, my lords, COVID-19, there were restrictions, but the companies were not disallowed from working altogether. If my lords have Annexure C, my lords please have Annexure C. I'll just read that out for my lords' benefit, my lords. Annexure C categorically says, and this is point 3 of Annexure C, all workplaces shall comply with the hygiene and social distancing norms as stipulated above, and any divergence from the same will not be allowed. The workplaces should provide for adequate health, food, and residential facilities if required for its workforces. Those workplaces operating in contravention of this clause shall be ordered to remain closed. My lords, it is absolutely clear, my lords, that workplaces were not barred.
Then the last point also says that only venture out for the urgent purposes. Don't you feel the people over there working had difficulty in accommodating and bringing in the raw goods?
My lords, I think, my lords, I very humbly submit that when the last point says the public should venture out for only those purposes, it is not referring to people who are working in these industries per se. It might mean common people like like me and my lords. So it is not referring to people who workplace.
I don't think that as an exception like that has been created under the annexure as you're trying to create. The annexure clearly says public is requested to remain indoors and everybody forms a part of the public. How do you create that whole distinction of saying construction workers will not form a part of this?
All right, my lords.
Are there any other judgments where the courts have said to this effect in terms of COVID-19?
My lords, no recent judgment comes to my mind, but if my lords have been reading the news, my lords, recently the construction processes all across Delhi weren't stopped. The Central Vista construction was continually going on even when the public was locked down.
So you're standing in a court of law and you're asking us, have we read a newspaper or not? If that's the basis of your evidences, then we shall give the judgment itself already.
My apologies, my lords. If I may proceed, my lords, with my submissions.
You may.
Very well, go ahead.
My lords, so all workplaces, my lords, I think the assumption is inherent in this notice that workplaces will be allowed to function, and that's why point 3 comes into place. If the intention of the notice was to disallow even workers from working, the point 3 wouldn't have been included as part of the guidelines of the COVID. The reason that it is because it wants to make an exception for these workplaces where people are working and there's essential work being carried out, my lords. That's how I see it, at least, my lord. At least I'll leave to my lord's judgment and scrutiny, my lords.
If you could explain then, you say this is a situation where things have become onerous. If you could explain what do you call an impossibility in the same facts and circumstances then?
Right, my lords.
What would amount to an impossibility?
Right, my lords. In the same facts and circumstances, impossibility would be, my lords, that tomorrow Britannia goes ahead and places sanctions on a country from which this particular company is receiving raw materials. And therefore, the company is not able to procure those raw materials, and there is nothing there with the company to even construct. That is impossibility, my lords. That it has become impossible for you to perform that contract even when you're willing to do so. In the present case, it's only your mismanagement of the company, Mr. Malfoy's mismanagement of the company, them being lackadaisical towards the needs and the demands of the workers, that the workers went on strike. And the straw that broke the camel's back was also the workers going on strike because they failed to provide for COVID protocol being implemented within their company. And that's the reason that on October 15th, all workers went to strike with 70% of the work being completed and 30% still being left. So it is conspicuous, my lords, that the reason that it has been made impossible.
Counsel, it's okay. Even if me and my co-judge accept your argument of COVID-19, how do you justify the fact that more than 30% of the work was left? What was the management at your team doing that they did not check in earlier and the work was still incomplete?
My lords, I humbly submit, my lords, and grateful for that question, my lords. My lords, routinely, my lords, I was communicating with Mr. Malfoy, and Mr. Malfoy had been giving me those assurances.
At least give me all the answers based on your fact sheet or the annexures. No assumptions on your end or newspapers.
I'll have to quickly go to that page, my lords. Please allow me 10-20 seconds, my lords. Right, my lords, if my lords have para 6, my lords, therein also it is made clear that Mr. Malfoy intends to complete the work. It would be completed by it's para line 3, my lords. It says that Mr. Draco had at the time assured him that the renovation work would be completed by Malfoy by September 30th, my lords. And this is Mr. Draco talking to my client and talking to Mr. Ronald talking to Mr. Draco and talking about the client, the completion of the work, my lords. And apart from that, my lords, right.
Counsel, who's the client?
Mr. Ronald, my lords. My lords, my time is up. If my lords must just allow me 1 or 2 minutes, I'll quickly wrap up.
Harshita, you go.
Okay, only 1 minute, then move on to the prayer.
Okay, my lords, in that light, I'll my lords, in the light of these above authorities and the position taken by the Supreme Court on force majeure, it is unambiguously evident that COVID-19 cannot be termed as force majeure in the present case, my lords. As the guidelines that I just apprised my lords when my lords were put a question to me, that it just spelled out precautionary measures which were to be implemented and nothing which barred the workers from working in the very first place. The workplaces were free to continue working and if they complied with the guidelines, and therefore the circumstances in and of itself had not altered.
Harshita, have we discussed the issue number 2 yet? It says whether there was a breach of contract by the defendant.
They haven't addressed issue 2.
We haven't, ma'am.
Then that will not be in the prayer, I think.
Right, my lords, right.
You're accepting that?
My lords,
that's on record now. Move on.
Are you conceding about issue 2? You don't want to argue? Then the defendants will not have to address issue 2 at all.
My lords, to give me another date, my lords, I'll quickly wrap up my submissions on the next date of hearing, my lords.
Very well.
Because we were sitting after lunch, my lords, I think it's time for the court to rise, my lords. So if you could give us...
You don't worry about our time. You get another 2 minutes now.
Right. All right, my lords, then I'll quickly go over issue number 2 of in today's thing. My lords, the issue number 2 is clear, my lords. Did the non-performance of contractual obligation by the defendant result in breach of contract, my lords? My lords, I'll advert to section 39 for this, my lords. Section 39 categorically basically points out effect of refusal of party to perform promise wholly, my lords. My lords, it states that, I'll just read that out for my lord's benefit. It says, when a party to a contract has refused to perform or disabled himself from performing his promise in its entirety, the promisee may put an end to the contract, unless he has signified by words or conduct his acquiescence in its continuance. My lords, the aforementioned section asserts that if a party due to his own act disables himself from performing his promise, then the other party can end the contract. My lords, in the present case, Mr. Malfoy, because of his own acts, because of his inability to deal with his workers effectively, because of his inability to ensure that his workers feel the environment is safe for them to continue working, those things led to him being disabled from performing the contract or his part of the contract. That is the construction of the...
Counsel, you're on the behalf of promisee or the promiser?
I'm sorry, my lords?
You're on behalf of the promisee or the promiser?
Promisee, my lords, promisee.
Go on.
Right. My lords, so in the present case, my lords, the defendants, due to their own internal discord, created circumstances time and again, which made it impossible for them to perform their contractual obligation. There was no third-party interference into their work. The disability stemmed from the fact that they weren't able to sort out their differences, my lords. Therefore, section 39 comes to our rescue in the present case, my lords. And I think, and my lords, I'll quickly also refer to another paragraph which I referred to previously. This is para 11 of the Moot Court Compromise. The workers, and I'll categorically quote from para 11 of the Moot Court Compromise. It says, the workers employed in Malfoy started to become impatient upon the delayed payments and the dismal management of the company in maintaining the hygiene and social distancing norms. The workers went on a strike on October 15th, and the entire operations of Malfoy came to a standstill, resulting in renovation project being only 70% completed. My lords, with this, it is absolutely clear that the management showing disregard to the needs of the workers and their demands not being fulfilled led to the stalling the work, and therefore the disability that has been shown in the present case has resulted from the person from Mr. Malfoy's disregard to his work, my lords, and therefore, my lords, the breach is on his part, and therefore I deserve damages as aforesaid, my lords. I'll quickly wrap up with the prayer, my lords.
Yes, please.
My lords, in light of the issues raised and the arguments that I have submitted in front of my lords and the authorities cited, my lords, the calculation of the damages comes to rupees 20,000 pounds. And this is the exact division is a compensation for damages paid to Mr. Harry is 4,000 pounds. damages for loss of business is £10,000, and damages for loss of reputation £4,000, and litigation costs £2,000. The total of this comes to £20,000, and this is in accordance with the settled principle for providing damages, that the person must be put in the original position that the person was before the breach happened. And my lords, what we've asked from this honorable court is in accordance with that. With that, that brings me to the end of my submission, my lords. I thank my lords for giving me a patient hearing, my lords.
Very good.
Thank you, my lords.
The counsel seeks permission to approach the bench.
Granted.
Good evening, your lordships and your ladyship. The counsel seeks permission to collectively refer to the bench as your lordships.
Granted.
Much obliged, your lordships. May it please the court, this is the counsel for the defendant, and I shall be presenting their case, that is Mr. Malfoy and his company, alongside my co-counsel, who is also present in this meeting today. The counsel seeks permission to lay down certain dates that would be important in this case to set the context before stating the issues.
We already know the timeline. If there's anything apart from that, please address only that very precisely.
Very well, your lordships. I don't have any separate specific dates to mention, apart from just one. That would be the date of contract between Mr. Malfoy and Mr. Ronald, the plaintiff, is 15th of December 2019, while the date of contract or the arrangement between Mr. Ronald and Mr. Harry, his client, is somewhere around June 2020. And that would be all. So if your lordships are satisfied, perhaps then I can proceed with the issues.
Please go ahead.
Very well, your lordships. Your lordships, there are two major issues in this case. One, whether time is of the essence in this contract, and two, whether there has been a breach of contract. And the counsel would be arguing the first issue, while my co-counsel will be taking the second. In whether time is of the essence in the contract, the counsel would be arguing the negative and exploring three major questions. One, whether the language of the contract can lead us to the conclusion that time was of the essence. Two, whether the nature of the contract was such, and three, whether the conduct of the parties suggested that time was of the essence in this contract. Your lordships may note that in the written submissions, there are three issues pointed out, the third one being where the liability lies. For the purpose of the oral arguments, these issues have been combined with the two major ones. So your lordships, once the counsel has proved that time is not of the essence, would be arguing that no liability lies still on my client to pay any compensation to Mr. Ronald. Second, then my co-counsel would be taking up the question of whether there was a breach and would be bringing in the argument from the perspective of there being a force majeure and doctrine of frustration being applicable. If the court is satisfied with the issues, perhaps I can proceed with advancing the arguments.
Very good.
Much obliged, your lordships. Your lordships, time to make time of the essence in a contract, the parties must show the intention, and that is the requirement under Section 55 of the Indian Contract Act. And to look at the intention, whether there was intention of the parties, we would have to look into the language of the contract first, your lordships. And the language must unmistakably show an express provision that would suggest that time was of the essence. Your lordships, a bare perusal of the contract would show.
Please refer to the annexure B.
Yes, your lordship.
It says, I assure you that we will be able to finish the project by October end. How more precise do you want your contract to be?
Your lordship, however, in the language of the contract, the intention of the parties to make time of the essence should be present while entering the contract, because that is one, perhaps...
Counsel, your party is clearly saying, I assure you that he will be finishing the project by October end. Please justify this line of your defendant.
Absolutely, your lordships, it's a negotiated date between the parties, and the negotiated date according to the
so
contract...
was the work done by that day?
No, your lordship. Unfortunately, that
Move
wasn't
on.
the case. Right, your lordship. So, your lordship, when we look at the contract, clause 2 mentions reasonable time. That suggests two things: that reasonability would change according to the circumstances, and two, that this can be negotiated between the parties, which cannot lead us to the conclusion that time was of the essence in the contract. Then we're looking at clause 4 and clause 5, which are speaking of delays, and the contract that therefore itself is envisaging a situation where there can occur certain delays in the construction itself. Therefore, again, time could not have been of the essence, because had it been so, then the contract would have been vitiated.
Harshita, are we able to follow the counsel?
Yes, I am. Although I'd like to ask a question. is it mandatory for a contract to have a clause that says time is of the essence, or can time is of the essence be inferred from the conduct of the parties as well, which in this circumstances, when you've committed to a particular date?
Much obliged for your question, Your Lordships. Your Lordships, the Council is referring this from a case of the Supreme Court of India, which is Gonathinagam Pillai versus Palaniswamy Nadar. Your Lordship, in that, it has been mentioned that the perhaps the contract should have unmistakably an express provision. And even if, Your Lordship, there is an express provision making time of the essence, there still needs to be a reference to the conduct of the parties and other clauses in the contract, which could perhaps lead to an alternative conclusion, which is that it was not necessarily, it was just mentioned the contract and was not necessarily implied or intended by the parties. Because, Your Lordship, even delay as an injury does not lead us to a conclusion that time was of the essence. Therefore, there must be more than just, and I conceded to Your Lordships that even if we would also refer to the conduct of the parties, and the Council will argue in the arguments later on that even the conduct of the parties could not have led us to the inference.
Let's hear that first then.
Yes, Your Lordships.
Council,
Absolutely.
just tell me one thing.
Yes, Your Lordships.
The entire contract here was something related to commercial aspect.
Yes, Your
Every day lost for any hall is profit lost. Don't you feel the entire work shows us that there was importance of time, there was essence of time? Also, as per the clause 1 of the annexure A, which says that, I beg my pardon, clause number 2, it says 5th day of January 2020 when it begins, and it gets over at 5th day of January of 2021.
Yes, Your Lordship.
So, are we not talking about time in either your annexure B, where your own defendant says that the timeline should be changed? Are we not talking about time in annexure A, which is the first piece of agreement between both the parties?
Yes, Your Lordship. Absolutely, you're right about that. But Your Lordship, we're again looking into this contract itself, the nature and the conduct of the parties. Even if we are consistently perhaps granting extensions, we are defeating the presumption that time is of the essence. The moment an extension is granted...
I don't agree with that. I don't agree with that. Please go ahead. If you have a justification to it, then please present that to me, or else just move on.
Sure, Your Lordship. Your Lordship, I would be for the argument that granting of extension defeats the presumption of time being of the essence. I'm referring to the case of Mankor Singh versus Hartar Singh Sangha, and that's
Is
also
that in the
Supreme Court
memo?
case. Yes, Your Lordship. That would be footnote
Page
7
number?
in the memo.
Okay.
Your Lordship.
It's okay. It's okay.
Right. Your Lordship, and further, we're looking here that the first negotiated date is 30th September, and the second negotiated date is 20th October. So again, extension is being granted, and we are talking about the conduct of the parties. And then, Your Lordship, an important point to note here.
What were the facts of this case?
In the Your Lordship, I'm sorry. Your Lordship, you would have to excuse the Council's memory. I'm unable to recall the facts presently, but I can get back to you as soon as...
you don't have the judgment with you, the judgment you're referring to?
No, unfortunately, Your Lordships, I would have to admit that I don't have them right now.
Then we reject this judgment of yours. Please bring in something else.
Fair enough, Your Lordship. I will be bringing another argument then in this particular matter and refer the judgment perhaps later. Your Lordship, we're again looking into the actions and the conduct of the parties, as Your Lordships has also asked to argue whether the conduct of the parties referred that time was of the essence. And in this conduct, Your Lordship, Mr. Ronald has not given any notice to my client when the work stops on October 15th. Mr. Ronald only files a civil suit when he has had to pay damages in the consumer court. Your Lordship, there is no such, and that cannot be the reason why we would assume that the conduct of the parties...
Obvious? Only when he has got damages upon himself, he is asking you for the
Absolutely, Your Lordship.
Damages.
Absolutely, Your Lordship. That is
what's wrong in that?
Your Lordship, that is natural for a person to do that. However, in terms of the contract,
so you're agreeing with the fact that this case is justified to take place?
No, Your Lordship. I humbly submit that is not justified, but natural. That I would assume that when you've had to pay certain damages in the court, you would want the other party with whom you think has the liability to pay to sue them.
So you think plaintiff has a point to prove here?
Yes, Your Lordship. I feel that the plaintiff should have proven that my client would have been responsible, and unfortunately, I feel that that has not been the case over here. Your Lordship, since the time is running short, I would just quickly sum up my arguments and give the time to my co-counsel.
No,
Because,
please do explain your arguments in detail. We have time.
fair enough,
We
Your
go
Lordship.
on.
Your Lordship, so I have argued from the perspective of the language of the contract. Then second, my argument would be the nature of the contract. The contract is a construction contract, which is a regular renovation work, not meant for any seasonal event. Your Lordship, to prove that this contract was supposed to make time of the essence, the plaintiffs would have to show that there existed special circumstances. Now, they may argue that the special circumstances was this wedding that was supposed to take place. However, Your Lordship, as I've already mentioned in the beginning of my submissions, that the wedding came into the picture in June while the contract was made on December. So something that has occurred prior to the entering of the contract could not be assumed to be a part of the consensus ad idem while signing.
Prior or later?
Sorry, Your Lordship, I stand corrected. Later, Your Lordship, something that has occurred later should not be made part of something that was prior, because that would defeat the principles of consensus ad idem, Your Lordship. And Your Lordship, my client so far,
Then why is the client accepting to a deadline and an NHB?
Your Lordship, that is simply out of friendship. If, as you may even note in the first private communication.
If it's all about friendship, then you should not be standing here.
Your Lordship, we are just responding to the summons of the court, where our dear friend has filed a case against us, where this could have been avoided. But Your Lordship, since we're defending parties, we must represent our case. But Your Lordship, in para 6 itself, we note that this was the acceptance on behalf of Mr. Malfoy was a friendly consideration. And Your Lordship, you'd note also that in terms of the liability.
Although the council has not asked for extension of time, Harshita, but we may grant that. Sure.
Before we do that, I just want to understand, should you not have addressed the fact, or do you not want to address the fact that this is a promise that has been made in a personal capacity?
Yes, Your Lordship, that would be...
Then does that bind the company?
Your Lordship, it shouldn't. I mean, as a
it shouldn't. I am asking as per law. Does that bind the company? Can somebody in their personal capacity bind the company? You understand the concept of separate legal entities.
Absolutely, Your Lordship. Your Lordship, I would agree with Your Lordships that this should not be binding the company. But in terms of this being Mr. Malfoy being the head of Malfoy Constructions, would also be the representative of the company in this particular communication, and so it could be assumed that, say, Mr. Malfoy has made a decision on behalf of the company in this particular case, and we could say that he has agreed on that.
No,
however,
you are not answering my co-judge. The question she asked is different.
Your Lordship, then could you please perhaps repeat your question, and I would try to answer it to the best of my ability.
Are not these two separate legal entities, and can somebody in their personal capacity bind a company?
Your Lordship, I do not think that as
I am not asking what you think.
I humbly submit.
What is the law in this regard?
I humbly submit, Your Lordship, that I would have to plead ignorance in terms of what provisions would apply here and what cases would apply here. So I would not proceed with arguing one thing or the other. And so Your Lordships would please perhaps excuse the counsel in that matter.
Okay. Your co-counsel can proceed with the arguments now.
Very well, Your Lordship. Much obliged. Thank you for your patient hearing.
Honorable greetings to the bench. May it please the court. Your Lordships, the council seeks your humble permission to begin with the second issue.
Yeah.
Go ahead.
Much obliged, Your Lordships. Your Lordships, the second issue is whether there was a breach of contract on the defendant's part. And my most humble answer to this particular question is a negative. And I would say that the defendant did not cause the breach of contract and cannot be held liable to pay the damages. One of the main reasons for this statement is that the delay that was caused, which affected the Hogwarts project, cannot be attributed to the company alone. As it was very rightly pointed out by my co-counsel, that the plaintiff very actively contributed to the delay by not following his part of the contract. And also, secondly, Your Lordships, the Hogwarts project that came to a complete standstill not, it was the complete standstill was not because of the because of any contractual obligations that were not fulfilled by my client, but it was because of the outbreak of coronavirus that practically stopped and made the performance impossible. In order to substantiate my arguments, I would like to draw your lordship's attention to the doctrine of force majeure. Your lordships, according to Black's Law Dictionary, force majeure means an event that can neither be anticipated or controlled and includes the occurrence of an unforeseeable circumstance that affects the performance of the contract and makes it impossible. However, your lordships, the party taking the defense of the doctrine of force majeure must try its best to mitigate the damages. Your lordships, here I would like to make a reference to the case of Delhi High Court in Messrs. Halliburton Offshore Services Incorporation versus Vedanta Limited. The High Court of Delhi very categorically stated that COVID-19 is a force majeure event. So, your lordships, keeping this particular case and the judgment in mind, I would like to also point out one thing to your lordships, that in order to take the defense of force majeure, there has to be a force majeure clause in the contract. But where there is an absence of a force majeure provision within the contract, there is still a possibility to take the benefit or to invoke the doctrine of supervening circumstance or supervening impossibility by way of Section 56 of the Indian Contract Act. This provision clearly states that in case of a contract to do an act becomes impossible to perform by reason of some unavoidable circumstances which cannot be prevented, then the performance will become unlawful and subsequently the whole contract becomes void. Your
Counsel, I
lordships,
agree to that. I agree
Yes,
to what you are saying.
Yes, your
But
lordship.
as per the 𝐻𝐿C, I don't think there's total urgency of you shutting down the entire business itself.
Your lordships, I'll come to that. Just give me some time. I am trying to lay down the prerequisites of these sections, and there I'll be taking up this particular issue and why this particular performance become impossible. If your lordships may allow me.
I would have liked if you clarified upon that one, but it's okay.
All right. Thank you. Really grateful for that, your lordships. Your lordships, the prerequisites of the doctrine of force majeure and Section 56 are in certain sense very identical to each other. One of the first and foremost prerequisite is the occurrence of an unanticipated event. In the present case, your lordships, the agreement that was signed between the plaintiff and the defendant, I humbly submit that certainly there was some discontentment between the management and the workforce. But your lordships, the company was trying its best to resolve the issue. If I may trouble your lordships to come to page number 1 of the Moot Problem, para number 5. My lords, has it?
Go ahead.
Yes, your lordships. Your lordships, this is page number 1, para number 5 of the Moot Problem, third last line from the bottom. It says that the management of the Malfoy had been constructively engaged with the trade union of workers to amicably resolve the issue and was responsible for considerable progress being made on all fronts. Your lordships, here the council, through the reference of this particular factual event, is trying to emphasize on the fact that there were certainly certain progresses that were being made. Therefore, your lordships, with in consideration of this particular fact, it cannot be anticipated that a future strike could happen. Therefore, the council is trying to emphasize that a future event like a strike should certainly be categorized as an unforeseen event. Your lordships, if your lordships are would allow me to proceed further with this particular prerequisite, I would like to talk about the second and very important event that happens, and that actually I'm really sorry for this, your lordships. Your Lordships, secondly, the event that actually affects the construction of the Hogwarts project is the outbreak of coronavirus, Your Lordships. As I've already pointed out in the case of Delhi High Court, Mrs. Halliburton versus Vedanta, Your Lordships, the outbreak of coronavirus can certainly be called an unforeseen event that affected each and every section of the society, affecting all the businesses and the activities. Therefore, certainly, Your Lordships.
Counsel, you are reiterating a point which you said 5 minutes earlier, and I asked you a question upon that. So I'm still waiting for the justification. So before you reiterate the point again for the third time, I'll ask for the answer. That based on annexure C, how can you say that your case was an impossible case?
Yes, Your Lordships. Your Lordships, with respect to the occurrence of the coronavirus outbreak, Your Lordships, this particular outbreak was termed as a state of health emergency, and the government had published various notifications and regulations restricting the normal conduct of businesses. Your Lordships, when this coronavirus outbreak took place, the defendant was trying to fulfill his part of the duty by diverting all the assets and workforces to the construction project. And when this thing did not take place and the strike took place, Your Lordships, the defendant tried to involve an independent contractor. However, Your Lordships, with the ongoing COVID-19 restrictions and regulations, the ongoing these restrictions, Your Lordships,
was all of this informed to the plaintiffs in advance?
This particular, I'm sorry, Your Lordships, what
all
exactly?
This information regarding making the third-party arrangements and the problem of workers going on, was this all pre-informed to the plaintiffs?
Your Lordships, in the Moot Problem, it hasn't been mentioned very explicitly. However, the defendant was trying his best, but due to the COVID-19 restrictions, he was not able to include an independent contractor to the project.
All right, while we are at the Moot Problem, let us look at para 11.
Yes, Your Lordships.
This is on page
number 2.
If I'm not wrong. It says, read para 11.
Your Lordships, para 11 says, the workers employed in Malfoy started to become impatient upon their delayed payments and the dismal management of the company in maintaining the hygiene and social distancing norms. Norms proved to be the last straw. The workers went on a strike on October 15th, and the entire operation of Malfoy Limited came to a standstill, resulting in the renovation project underway at Hogwarts Garden being only 70% completed.
So would you not say that the defendant was directly responsible and it's not the COVID-19 pandemic that you can take as an excuse now, given you did not provide the right circumstances to your construction workers?
Yes, Your Lordship.
And if my co-judge would agree with a bit of maths, from January till October, you could just finish 70% of the work. You were expecting to finish off the 30% of the work in those remaining number of days?
Yes, Your Lordships. That's why that's why the council is. That's why the defendant was actually trying to involve an independent contractor, or the defendant certainly diverted all the assets and resources that were earlier employed to the other projects of the company. But
did you not inform the plaintiff yourself that by October 20th you'll be done with the work?
Certainly, Your Lordships. But however, I would like to point out one thing. If your Lordships may come to page number 2 of the Moot Problem, paragraph number 6. My Lords, has it?
Yeah.
Yes, Your Lordships. So, Your Lordship, in the paragraph number 6, this particular paragraph refers to the communication that took place between the plaintiff and the defendant. In this particular paragraph, in the conversation, in the communication between the parties, the defendant informs the plaintiff about the delayed payments. Your Lordships, my client was very considerate and accommodating while the plaintiff said, and I would like to put this thing in your consideration.
Counsel, but your client himself in the third line says that Draco had at that time assured him that the renovation work would be completed by Malfoy by September 30th.
Yes, Your Lordships. I just want to point one thing, if Your Lordships may allow me. Your Lordships, in this particular para, if you take fourth line from the bottom, it says, fifth line from the bottom, the plaintiffs apologized. He apologized for the delay in payment of the amount due and marked that the same had been due to the sluggish economy and the Hogwarts Garden being out of business for the past 6 months. Now, your Lordship,
Time's up.
if you're,
I think both the councils have not been obliged enough to have asked time from us, but it's okay. As your council did not ask, you also did not. We'll give you some time. Say 2 minutes, Harshita.
Yes, fine. 2 minutes. Wrap up with your prayer.
Certainly, your Lordships. Your Lordships, what the council is trying to point out from these particular factual events is that if your Lordships come to first page now, page number 1, paragraph number 3, last line. My Lords has it? Yes, your Lordships. Your Lordships, here this particular paragraph talks about the contract that took place between the plaintiff and Mr. Harry. Your Lordships, if I may read, the total cost of wedding at the said venue for the marriage or to be attended by 500 guests was negotiated to be at £50,000, and a token money of £10,000 was immediately paid as per the prevalent standard practice. Your Lordships, in the subsequent and this particular event takes place in June 2020, your Lordships. And the communication that I was referring to in paragraph number 6, that takes place in July 2020. Your Lordships, here the plaintiff is very explicitly saying that he has not been able to do any business. Therefore, your Lordships, it should be considered a complete lie, and it should be considered that the plaintiff was trying to avoid his part of the contractual obligation. So, your Lordships, in the previous...
That's a very strong word you're using right here.
Sorry, your Lordship?
That's a very strong word which you're using. That's a complete lie. Please substantiate that.
Yes, your Lordships. Your Lordships, in the paragraph 3, as your Lordships can point out that the plaintiff has received £10,000 for the wedding. And in the subsequent month, during the communication, the plaintiff is saying that due to the sluggish economy, the Hogwarts Garden hasn't been able to do any business and is completely relying on the economical situation. Your Lordships, I would like to point out one thing here, that the economic situation is the same thing for both the parties. My client was also suffering from the same economic problem. However, my client was very considerate in accommodating the request of the other party. In the subsequent communication that is annexed as Annexure B, the same same issue of payment was again raised by my client, and the same was declined. Your Lordships, this particularly these factual events very categorically point out to the fact.
Just proceed to your prayer now.
Yes, your Lordships. Your Lordships, in the light of the issues raised, arguments advanced, and authorities cited, it is most humbly prayed that in the interest of justice, the Honorable Court may be pleased to dismiss the claim of the plaintiff that time was of the essence in the contract. Secondly, dismiss the claim that the contract was breached by the defendant. Thirdly, declare that the contract became void under Section 56 and Section 53 of the Indian Contract Act, and pass any order as it may deem fit in the interest of justice, equity, and good conscience.
All right.
It was a pleasure arguing before this bench.
Thank you, everyone. Thank you, firstly, to Harshita and Yash. Thank you so much for taking out the time from what I'm sure are extremely tight schedules, and that too on a weekday. So again, thank you so much. It's been an absolute pleasure for us, and I'm sure an absolute pleasure for the 4 students who got to argue in front of you. And our apologies for any mistakes or goof-ups that we may have made in the process. But
no, definitely no.
So with that, I would like to move on to the next part of today's session, which is basically going to be a brief about the upcoming events, the process for getting inducted, and we'll also have a brief interactive session where we'll be entertaining a few questions from the audience. So Harshita, Yash, we would love to that you guys get to stay back. In case you don't have the time, which we understand, you are most welcome to drop off. So as per your wishes entirely. Having
We'll
said that,
stick around for the interactive session.
all right, so just give me 5 minutes to just go through everything, and we'll move to the interactive session. So firstly, I'll talk about the induction process. So we, as I said, there are two inductions that happen. One is the freshers induction moot that is exclusively for first year students, and the common induction moot that is open to students from all batches. Now, for this academic year, the common induction moot has already taken place. It happened in October, and we saw participation from second and third year students only. Unfortunately, because of the incongruent calendars, first year students could not participate. However, we will be having the freshers induction moot in the coming month of February, the exact details of which will be out soon. And and all first year students are welcome to are not just welcome, but are encouraged to register and participate in the same. The induction moot is a simple process. So we release a problem, and you are expected to prepare what is called a memorial. A memorial is basically a written a summary of your written, basically it's your written submissions with a few additional things here and there. And after that, we have the oral rounds where we get judges from outside, judges like Harshita and Yash, to judge students on their oral rounds, and they are and based on that, they are inducted into the society. There is no fixed number of students that the society inducts through any induction moot. There is a certain absolute bar. So if you have the minimum number of marks, you are automatically inducted into the society. Students can participate as plaintiff or defendant. I mean, they have the option of choosing the side as well. And we, for the benefit of first years, we will be holding 3 workshops between the time we release the problem in this week and the time that the freshers induction moot happens, where we'll be covering every aspect. So we will be talking about how you approach a moot problem, how you draft a memorial, how you do research. And we also have one workshop dedicated entirely to oral argumentation, the court mannerisms, etc., etc. Besides that, this year in March, we will be hosting what is the not just the societies, but I would say the go far as far as saying CLC's flagship competition, which event, not just the competition event, which is the K.K. Luthra Memorial Moot Court. It's going to be held virtually this time because of the pandemic. However, given that it is a mammoth task and a mammoth logistical exercise, we generally do rely on volunteers from across all 3 batches. And we would be absolutely delighted to have first year students show an enthusiastic response to the same. The preparations for the same will also start somewhere in the later half of February. And again, the details of which we will surely put up on the on our Facebook page, etc., and the CLC website. Besides that, we keep having workshops every few weeks where we invite alumni and other lawyers or practitioners talking about various aspects of mooting, of research, drafting, ADR, mediation, negotiation, etc. Again, everything is publicized on all our social media platforms through which you can, gain access and you can take part in that. And we are planning to start this year something called, we basically have oral round practice sessions. So after the FIM, we will regularly host practice sessions where we'll provide a memorial and students can then brush up their oral skills through internal practice sessions for the members of the Moot Court Society. Again, as I said, please make sure that you are following our social media handles. Prerna has been kind enough to put those links on the Google Meet chat. In case, and of course the CLC website, just as a heads up, we will be announcing the process for the freshers induction moot. Yes, so as I said, we will be announcing the induction process within this week. So the schedule, the problems, the rules, the details of the workshops will all be encapsulated in those announcements. So we would request that you keep track of the Moot Court Society Facebook page, the LinkedIn page, as well as the CLC website. All these details will be posted everywhere. now we would like to move to the interactive sessions. First, we will take questions from students who are part of this meeting, and they can switch on their cameras as well as their mics and pick Yash and Harshita's brain if they want. And after that, we will take up questions that are on the live chat. So if there are any first year students who would like to ask questions, then please, the floor is open to you. Okay.
Looks like they're reluctant.
Seems like,
or they have it all
we've
sorted.
got one person. Yes.
Ma'am, there are various questions in the chat box if you are kind enough to check, ma'am.
Okay, we can. Harshita, would you like to take them up?
I think they're more directed towards the society.
Fair enough. So I'll just quickly run through them. So yes, for those from the okay, first we'll take the Amar Aryan, please. Why don't you go ahead?
Sir, can we debate in Hindi language?
No, mooting is exclusively in English. There are certain moot court competitions that do happen in Hindi, which we open for members and non-members. But the induction moots are exclusively in English because the language of the High Courts and the Supreme Court is English.
Okay, sir. Thank you. Thank you.
Shrikant Sharma.
Good evening, sir. Good evening, ma'am. Ma'am, I have one question. I want to join PAC and CCLS also. So can I want to be a career in corporate. So how can moot courts help in corporate sectors also? Like I don't want to go in a litigation. So can we moot courts help me elaborate in corporate law also?
Yash, would you like to take that?
You take the lead.
See, mooting is not about taking up litigation or taking up corporate law as your career. It's something that helps shape your personality because it will help you gain confidence overall when you're speaking in front of a crowd of 100. Right now it's virtual, but otherwise when we had it in our times, we would speak in front of a lot of people, and facing the judges itself is something that helps shape your personality, lets you have that confidence when you have to think on your feet. So don't take mooting as something that you should take up only if you want to take up litigation as a career. Don't restrict yourself, and it's something that will also help you learn teamwork and other personality development traits that all of us would want to have. And being a part of the society and taking up mooting will help you learn that. In fact, it will also help you learn the law because once you take up a moot problem and you prepare the memorial for both sides, you will realize you have to be very thorough with the law. So it's not something that is restricted to people who will take up litigation, take up whatever career. This is something which will help you always. So don't limit yourself.
And if I may add to what Harshita said, because of the intensity of research that you have to do, you hone those skills that will benefit you wherever you go. I mean, I'm sure even corporate lawyers have to delve into, through a quagmire of regulations and laws and etc. And the skills you pick up while you're preparing a memorial will help you even then. So as Harshita said, you don't benefit yourself by restricting yourself. Utilize all the opportunities that come your way.
I think we have talked a lot about benefits, both of these people. I mean, they are both champion mooters itself, be it Harshita or Madhav. But I feel just the activity, just the act of doing a moot, of being there, being in a new college, new people, the kind of exposure you get is a lot. I think anybody coming to CLC, they should, of course, be it first year, second year, they should take part in the MCS because you get to experience the intense pressure of litigation or corporate, both ways. That really helps you. And it's not about winning or losing, trust me. When you make that entire memo, you see that, when you submit that feeling in itself is something which makes you feel, yes, I've accomplished something. That is more important.
Okay, so we have Harish now, who had a question. He had raised his hand.
Yes. I want to know that I'm requesting you, could you please post the memorials of the both plaintiff and defendant on Facebook witnessing the demonstration?
We'll do that. We'll do that after the end of the session.
Okay. Thank you very much.
Then there was one more person. Okay. So I'll just start taking the questions on the chat. So we will be posting a.
Madhav, there is
sorry.
M. Singh whose hand.
Oh
is
yeah,
raised.
sorry. M. Singh. Please go ahead.
Hello everyone. Sorry for the name. Actually, I wasn't able to join with CLC ID, so I joined with another ID. Sorry for that. I just wanted to ask that you said that there will be an induction process, like we have to submit memorials and then the oral process, oral induction process. I was watching this live Moot session, and there were many legal terms like your counsel, the counsel wants to present this, and your lordship, and there was certain manner in which the counsel was speaking to the judges. So I just wanted to ask that how do we get to know all this, and how do we prepare the memorials and everything, as we don't know much about any of this? And also in the morning session of orientation of CLC, we were able to see that only 65 students were able to join in 2021 in first semester. So I am guessing that there is a lot of competition to join in Moot Court Society, and as I am very enthusiastic to join this society, so how do we hone our skills so that we can be able to join the society? I just wanted to ask that.
I think I'll let Harshita handle this one. I think she's the better
No, this is
expert.
something that Madhav and his whole team will help you learn, which is why they are going to conduct workshops for you guys. And you always have YouTube videos to refer to. See, this is not rocket science. This is as simple as learning those basic court etiquettes, which, if you take up litigation also, will help you throughout your life in that sense. So it's not a tough job. All of us have been a part of the society, and it just requires a little discipline from your end, and that effort. If you put in that, there is no, at least in our times, there was no limit to the number of people who would be taken as a part of the society, and I think that stands still. So if you're able to clear the minimum benchmark that exists, you'll be a part of the society. There are no two ways about that. It will require discipline and effort and guidance from the society members, which I'm sure Madhav and his whole team will provide you through the workshops.
So, like, the thing here is that at some point of time, Harshita, Yash, myself, and everybody else that you're seeing on the screen, we also knew nothing when we came to CLC, right? So even we also learned through workshops, and as Harshita said, really it's more about discipline and hard work than anything else. So if you're willing to put that in, then there is absolutely no reason why you will not be able to make it into the society. I know personally there were people who were scared of stepping in front, public speaking, and they have become fantastic mooters over the course of the 2 years. And so students can really, it's nothing, not that, you need to have some God's gift to be able to get into the society. And there is no competition per se. You're really only competing against yourself. You just have to clear that benchmark. We are more than happy taking 200 students also through an induction moot if they clear that benchmark. And the philosophy of any induction moot, and that is what we also tell our judges, is that it is a catch-all process rather than, it's not about eliminating people. We want more students to be part of the society. So the induction is only a way of making sure that students who are serious about mooting and who are able to put in that effort are part of the society, and people who are not serious do not make it to the society. But it's not like you need to, you do not need to be a 𝐿𝐴 from the first day in order to be able to get into the society. We all started knowing nothing. Yes, Rupal.
Can you elaborate a little bit on the syllabus that we're going to have for the induction process? Because while I was listening to this moot, there were a lot of terminologies that I did not know. So I really don't know, will we be taught all of these things in our first semester, and how will we be able to actually crack it?
So the FIM typically revolves around contract law and tort law. So these are subjects that you will have in your first semester, but because the freshers induction moot, as I've already stated, will be happening in February, you will be done with that long before maybe the class your teachers are able to get to those particular topics. What we would suggest is that like what everybody has done is that you do start reading up on issues on the Contract Act and things like that. And once we have the problem, once you've released the problem, you will realize that exactly what area of contract law, tort law you have to focus on. And we give a sufficient time for people to prepare their memorials and their oral arguments, time that historically has proven to be more than enough for students to come up with quality memorials and quality oral arguments. And you'll be able to utilize that time to get yourself familiar. Besides that, we will certain terms like how to address the court mannerisms, where do you counsel, your lordship, etc. We will be holding workshops for all those things as well, and you can attend those workshops and get an idea of how things happen there.
And what's a memorial exactly?
So a memorial is basically bulk of the memorial is basically a detailed written argument. They're your written submissions. There are other aspects to a memorial, like you'll have to talk about the jurisdiction of the court, statement of fact, summary, but they're slightly more mechanical exercises. But we have what is called an arguments advance section in a memorial, which is the bulk of the memorial, and it is essentially, as I said, a written submission. We will be posting 2 memorials on the Facebook page after this session, and you can refer to it and get an idea of what a memorial looks like. We will also be hosting a workshop towards the end of the month on how to draft a memorial.
I have one more question from Yash sir and Harshita ma'am. It's a little bit different than this particular topic, but because you are seniors, because MCS in itself a hefty task. I mean, preparing an entire memorial and everything. How did you people manage to balance your exams, this co-curricular activities, and then internships in itself, which is of course an important part when you're studying law? So how did you all manage, and what would you suggest to the freshers? Because right now it's quite an overwhelming experience for all of us.
If you're serious about moots and if you actually work, you'll realize you have 4 hours to sleep, get up in the morning, run to the photocopy shop, then come back, see that your teammate is sleeping, then kick him up. Then you realize that your classes are going on, go to the classes in mid-lecture, see a teacher taunting you that you don't study but going for the moot. So you don't really manage. You just are happy in that chaos. You feel good. You feel dejected at times because you're not getting the proper judgments. At times you feel like that the college should help you more. At times you feel that no, the competition will be very tough. So I really don't think that we managed. We just happened to be in that chaos, and I think that is more about it.
I may have a more structured answer to that, I would say. So what I used to do personally was take up a moot of a subject that was there as a part of that particular semester. In that way, I was able to study for the subject and prepare for the moot alongside. So I wouldn't have that pressure that I'm doing something very different. I would have that motivation. Ultimately, this is going to also help me in my exams. So maybe you could take that approach, but you have very little choices given limited moots open up, and then you also have to give internals for them, clear them. That whole luck playing in that you're able to have the same subject as your moot problem is difficult, but it's not that difficult. You would be able to manage with it, I think. So one thing is that. Also, you can divide and understand which semesters you want to focus more on internships, like in your before your odd semesters begin, there are summer breaks. So maybe that is the time you'd want to do internships and not when college is going alongside. So you have to balance, in the initial years, maybe focus more on mooting. And then when you know the law better, then you focus on internships because you'll be able to provide some inputs also in the true sense when you intern. It's all about balancing at your own end and being able to understand what fits right at what time for you. And don't want to do it all at the same time. You will end up doing nothing. If you decide this semester you're going to take up a moot, give your best to it. Then leave everything else aside. Next semester you decide you're going to do a research paper, give your best to the research paper then. don't go into the rat race. He's doing a moot, she's doing a moot, I should also do a moot if you like it, you are interested in that particular field of law. Otherwise, don't do it for the sake of it. At that, I would say, Yash and I will take your leave now.
Thank you so much.
I think Madhav will be able to address all other questions very well, given he's equally experienced.
That's not the case, but thank you so much. I understand that you guys have other pressing commitments, and thank you so much, Yash and Harshita, for joining us. It's truly been a pleasure.
We're glad you hosted us. We were glad to be here. Thank you for inviting us.
Thank you.
And thanks to all the teachers there. Thank you, ma'am.
Yes, thank you.
Thank you. Thank you, Harshita. Thank you, Yash.
Thank you, ma'am.
Okay, so we have Satyam, you have a question.
Hello, good evening, sir. Sir, I just want to know what are the parameters on which we are going to be judged throughout the induction process.
So, Satyam, we will be releasing, as I said, as I've already stated, we will be releasing the rules, the problem, and the schedule for the FIM in the coming week. All these details are going to be there in the rules. It's not a long document. It's an 8-9 page document that you will have to read, which is barely anything given the fact that you want to be a lawyer. And all those details are there, and they're fairly self-explanatory. Very honestly, they're done in a manner that are very self-explanatory. So we don't want to get into those things here because they're technical terms which you will be able to understand better when you go through them.
Sir, if you can share your personal experience, how to brush up the mooting qualities.
The best way I know how to brush up your oral argument skills is go to court with lawyers, with good senior counsels, and just see how they present arguments, how they manage the court, how they deal with the googlies that are thrown their way, and how they think on their feet. I know that's how I learned.
Sir, as it is a pandemic time, so what we should do to brush up all this?
Yeah, as Ajaz Shatru said, watch proceedings in the Delhi High Court. I know for a fact that Gujarat High Court live streams all its proceedings, so you can, go for that. Do an internship maybe there if you do it with a litigator, with an advocate, and they are arguing regularly, then you'll get to see them argue. Then you'll also get to see others argue. So that is the only way that you really get experience. Otherwise, you can look at YouTube videos of Moot Court competition finals, like some good competitions hosted by NLUs or international competitions. They post videos of their finals online, and you could look at that and see how experienced mooters are able to navigate issues and handle judges, etc. So those are avenues that you can use, and otherwise generally improve on your English speaking ability. Read as much as you can. The more you read, and not just law, but in general, the more you read, the more comfortable you'll get with the language. The more comfortable you are with the language, the easier you will find it to speak when you are put in a public setting or when you're put in an awkward position by the judge.
Sir, can you please suggest some websites or any online platform through which we can get enough material as far as law is concerned for the whole law, means especially for moot court competition and all that?
See, as I said, so Loctopus is a very good website. I'll request one of the EC members to put the link in the chat. Loctopus is a good website that has a lot of material with respect to moot courts, but in general, you just use WhatsApp. You just YouTube stuff like moot court competition finals, things like that. So if you want videos, you go there. For legal, for material, you typically, as I said, Loctopus has a huge treasure trove of memorials. And for books and authorities, you have your standard SEC, Manupatra, things like that. And of course, you have the CLC library.
Okay, sir. Thank you. Thank you for such an exhilarating
Also,
session.
if I may add, please read live law regularly. I think that will help you more than anything else.
Of course.
Okay, sir. Okay, sir. I will.
Bar and bench and live law. Yeah. Akhilesh, you had a question?
Yes, sir. Good evening, sir.
Good evening.
Sir, can we attend a session without part of Moot Court Society?
So there are certain sessions that we open to everybody, and there are certain sessions that are open only to members of the Moot Court Society. The member sessions that are open to everybody are typically publicized, through social media, etc. And there is a specific stipulation that everybody can attend. So there is no
Okay,
hard
sir.
and fast.
Okay, sir. Thank you, sir.
We have a question from one Yukti Saluja.
Am I audible?
Yes.
Greetings, everyone. My question is how to get rid of that stage fear and be more confident. If you could tell.
I think that's a difficult one to answer, to be very honest. And I mean, I'm at my wit's end. Is there anybody who has ideas on how to?
So I would say that there is no shortcut for that. You just have to practice and practice and practice. So you learn things with experience. Once you are arguing in a court, like you'll be arguing in the FIM, then you will be signing up for moots. There will be internals, and then you might even qualify for moots by other universities. So that is the only way to get rid of your fear.
And also, you're not going to be doing any moot alone. You'd always have a team with you. So remember that's also there. And you can practice with your teammates whenever you're preparing. So that's something that will help with the confidence.
Thank you.
Simply don't worry about others. You should be confident yourself.
Right, sir. Yeah, Tanmay.
Good evening, everyone. I just want to ask that are we going to have any training session before the actual induction?
Yes, as I've already stated, and at the cost of repetition, we will have 3 training workshops on different aspects of mooting, starting from how to read a moot problem all the way up till court mannerisms and oral arguments.
Okay, thank you. Thank you so much.
Yes, Raveen.
Good evening, sir and ma'am. My question is that, sir, there is a language barrier or not, sir?
English is the language that, at least for the induction moot, English is the language that is used exclusively. After that, there are competitions that are in regional languages, but by and large, you will find moot court competitions being in English language.
Okay, sir. Thank you, sir.
Thank you. Okay, now, right. So,
Let's answer some questions on the chat box.
I'll now first take some questions from the chat box. People can raise their hand and form the queue, and then we'll come back to that. So, number one, yes, you will be able to see the recording of the session afterwards. It will be posted on Facebook. When the inductions for FIM will happen, they will happen in February. The exact schedule will be posted along with the problem and rules and all other details within this week. So we request everyone to keep track of the Facebook page. Typically, most competitions that the Moot Court Society opens on the basis of only for members of the Moot Court Society. We do regularly open competitions for non-MCS members, but they are not as many number as those that are open for the Moot Court Society. There's a question about syllabus for inductions. As I already stated, the problem will be focused on contract law and tort law, or a mixture of the two. The exact details you'll get to know once the problem has been released. Then again, we'll be posting memorials of the plaintiff and the defendant on Facebook. Yes, you are most welcome to contact any of us with any moot related help that you require. Our numbers will typically be publicized on the notices, and you can feel free to reach out to any EC member at any point of time and seek their guidance or help. That is not a problem at all. Now, I will elaborate on the process of freshers induction moot. We release a problem and you are given, and we host workshops in the middle. There are 2 things that students are essentially supposed to do. One is that they are supposed to submit a memorial for the site that they have chosen within the deadline that is set out in the rules. Once they have submitted the memorials, a few days after that, we have the oral rounds for the competition. The oral rounds, they will be each student will present individually in front of the judge their side, and they will be marked by the judges. Those students who qualify the minimum criteria for both the memorial round as well as the oral round are inducted into the society automatically. FIM is an individual exercise and not a team exercise. What should be the preparation strategy for the induction moot? you can read up on contract law, you can read up on tort law, but essentially you have to, there is no preparation strategy per se. Once you have the problem, you are expected to analyze the problem, identify the key issues involved, research authorities and case law for those issues, formulate arguments, prepare a memorial, and then prepare for your roller rounds. There will be, I understand the students are not familiar with conduct and language to be used in court. And yes, there will be a session closer to the oral rounds of the freshers induction moot, where we will be telling students about about court mannerisms. With regard to whether this moot court society is only for is exclusively for students of the CLC, that is true. Only CLC students can participate and be members of the moot court society. Yes, you can be part of multiple societies at the same time. There is no restriction per se. There's a question about how you can excel in the art of mooting. As Dropta said, it is simply about just doing it again and again and improving one after the other. There is no other way to do it. What is the benchmark to get into the induction? Those details will be in the rules. You are requested to kindly go through the rules in a comprehensive fashion. And if there are any questions after that, you can email us. And then there is link for proceedings. Again, as I said, oral arguments in FIM are done by an individual. Thanks, Ajaj, for answering that. And is it possible to manage other societies along with the moot court society? Most definitely. It depends on what all things that you want to do. There are people I know who do internships, moot court society, academics, and 20 other things. There are. So I'm sure if they are being able to manage it, you can do. It requires a certain amount of time management and discipline and hard work, but it's not like it's impossible. I know, like Harshita, for example, was part of 2 societies. She did internships. She was very good academically. So, and I'm sure there are members in the EC who are also discharging multiple responsibilities and looking after multiple things at the same time. So there are, I'm sure with the right mindset and discipline, anybody can do that, especially in the online mode. Things are much easier nowadays. So those who do not use Facebook, they will get to know about the process. They can they can go to the CLC website, but I would suggest people who are not on Facebook to please do join Facebook, or otherwise do join LinkedIn, one of the 2 platforms, because that's where we post pretty much everything. So that will help you get, that will help you get live update. You get you real-time updates, and you will not miss out on anything. So I would suggest that you set up a Facebook account in case you haven't already. So there is no WhatsApp link per se. There is a WhatsApp group for members of the Moot Court Society. Up until the time that till the time you're inducted, any communication that will happen through the Facebook page. And you can ask your questions either on personal chat by approaching individual EC members or during your workshops. How much time will we get after the notification? Again, all of those details will be there in the schedule. Ajat Chatru sir, how to contact you? Ajat, please, that is, I think, directed at you. Instagram, we are on Instagram, but you can't post PDF documents on Instagram and things like that. So you will get updates there, but you will Facebook and LinkedIn will be more comprehensive. So there is so there is no clearing the memorial round. As long as you submit your memorial, you can participate in the oral round, and based on a composite analysis of your memorial and your oral rounds, you get access to then you are automatically inducted. But there is no first elimination of memorial round and then elimination in oral rounds. Both of them are done at the same time. But yes, if you have not submitted a memorial within the deadline, then you will not be able to participate in the oral rounds. Are there any people who have questions besides this, or we'll wait for another minute? Otherwise, we'll close the session.
We might have something from the live.
Rushika, do we have something from the live chat?
Rushika, please.
I have posted all the relevant questions. Just one last is left. Let me just post it.
Or just say it here. That's okay. We'll just answer it. as students of the moot courts, I mean, I cannot comment on the center allocation. I am extremely sorry. That is beyond my control, and that is something you'll have to take up with the college administration.
But could you delay this process, because if you know 200 students are stuck into this, so we request you for that.
As I said, we'll deliberate internally, but I cannot make any promises as of now. What platform should we exactly use? That is up to you. That is up to your individual discretion. However, there are, I mean, all of us are available on WhatsApp for sure. And most of us would also be available on various social media platforms, and you can approach us through that. Can we get all updates on LinkedIn? Yes, you can. How can you connect with MCS members? So in the notice, we will be providing certain contact details. And can I just, in the meantime, request one of the EC members to compile the contact information for all 14 of us and put it on the chat? And LinkedIn link and everything are LinkedIn. The link for LinkedIn profile, Facebook and Instagram profile is in the chat. If you just scroll up, you will find it there. Prerna, could you just post it once again for everyone's benefit? Yes, once you get selected and become members of the MCS once through any induction, be it FIM or CIM, you are members for the next 3 years of your college life. You don't have to do the induction again and again. So, for example, I cleared CIM in my first year. I have not had to do an induction since then. A lot of the second years here cleared FIM in their first year, and they haven't had to clear any induction ever since then. So, once you're in, you're in for the next 3 years. Can one person also just take up the charge of putting in phone numbers for the EC members?
I'll do that. I'll just post it here.
Thank you there. See, yes, LinkedIn, whether you want to join Facebook or not, it's up to you. But yes, we typically put everything up on LinkedIn as well as Facebook. All right. I think we've had a fair amount of fairly long session. Now I would like to invite one of our teacher members, Cholaraja sir, to kindly give the vote of thanks. Sir, over to you.
Yeah, thank you so much, Madhav. Due to the Pongal festival last day, everything, you maybe get it little bit, noise also in my background. So that is the main reason I couldn't able to on my video camera also, because, the festival day is going on last day of Kanum Pongal. So that's the main reason I couldn't able to open my video. But don't mistake me. I apologize to everyone on behalf of myself. First, it's not good way to, give the vote of thanks. Unfortunately, the festival is going on. That's why I couldn't able to open the video camera. So now I will try to give the vote of thanks for the entire team, the Moot Court team, as well as the two judges, especially Harshita and Yash. Personal thanks to them, as well as on behalf of our law faculty, particularly Campus Law Center also. Then particularly, this team, the work is properly going in the manner, the systematic manner. Madhav and that is Moot Court convener, and all members, they are working tirelessly, and particularly, there is no time limit. 24/7 they are working. Really, thank you so much. Without your working, the way of skill, the spending time, I know very well. Madhav and the entire team, thank you so much to everyone. Then the hardcore team of your teacher convener, that is Dr. Harleen Kaur. She is the basic, the bottom of entire things she's controlling, and she gives this all the time, when you are calling and all the things. And thank you so much to the Dr. Harleen ma'am also. Then our PAC, that's Dr. Alka ma'am, and with her kindness, and anytime when we contact all the update and all those things, we get particularly her support each and every time when we message, when we called. So personal thanks to our Dr. Alka Chawla, PIC, Campus Law Center. Then our Dean ma'am, Usha Tandon. She also from CLC only. She's currently taking as in charge, as a charge of Dean of our law faculty. So we will convey, I will convey on behalf of our Moot Court team. Thank you so much, ma'am, also. And who the participant, nearly 100 participants. I saw that the whole nearly 5 o'clock. I joined 4:45, then till 7 o'clock, and most of the members, they are not leaving there. So I congratulate to them as well as thank you so much for your participation, because these are the way it is giving the boost to our team. Our team means Madhav is the team leader of that, especially the convener Madhav. Thank you so much, Madhav, and overall. Okay, Madhav, Harshita, Yash, and all the members, and Dr. Harleen, Kaur, our Moot Court convener, then Apanjot ma'am for the welcome address, and all our teacher members, Nega, Neja ma'am. Actually, I couldn't able to call each and every one name, but I will tell you. Our PAC ma'am, then 𝐿𝐾𝐳𝐻 ma'am, then our 𝐬𝐶 ma'am. So I thank you so much to each and everyone. We should meet some another one big occasion as soon as possible. We will get it soon. We will meet. Thank you so much, Madhav. Especially, I'm telling to, he is messaging to me last 3 days. Sir, is it possible to you or not? So really, he reminding me. That should be very important. Thank you so much.
Thank you, sir. Thank you so much, sir.
Thank you, Dr. Chola. Thanks.
Yes, Didi. Thank you, Didi.
With that,
Thank you, everyone. Madhav, I just want to add on to what Cholaraja sir. Wonderfully
Definitely.
organized. Heartiest congratulations to the entire team. So for this wonderfully organizing this entire event. All the best for the FIM and coming events.
Thank you so much, ma'am. And thank you everyone for joining us. And we look forward to hosting you in our subsequent workshops and FIM. And hopefully we get to meet you all very soon in campus. Till then, please stay safe. Please stay happy. Please stay healthy. And we wish to see most of you take an enthusiastic part in FIM. And please feel free to reach out to us in case we can be of any help. Happy mooting. Thank you. Bye-bye.
Can everyone just please hang on if you want the contact details? I'm just sending it here in a second.
Yes. Yes, Sharik. Sharik, you had a question?
Yes, sir. I want you people contact number.
Yeah, we're just putting it on the chat.
Thanks.
Can we just check the live stream once, please?
Yes, Arjun.
Hi. Yeah, my question is not related to MCS, but could you guys please guide us? How can we apply for internship and where all should we apply in first year itself?
I don't know how to answer this. Second years, would you like to take that up?
Is it about applying for internships?
Yes.
Yes.
I think in your first year, start with lawyers who are not very prominent and for whom many people might not be vying for in terms of sending them applications, because it's important for you to just get acquainted with the basics of litigation in terms of what is an affidavit, what is an application, what is the next date of hearing, all of those aspects, and those things can be learned from anywhere. So send as many emails as you can. Have a draft of that you will send to people. Have a CV in place. I think CV becomes extremely important, because when you apply for any internship, you have to send your CV along with it. It's not just you sending a request saying that please provide me with an internship. So have a CV which is well formatted. Put everything that you have done in the past into that CV. And the key is to try it as many places as you can. If you try 100 places, you might just receive a callback from like 1 place or 2 places or 3 places. So keep applying. And if you want email IDs, so one hack of getting email IDs is, as I said, if you go to Delhi High Court website, if you go to the cause list contains the email IDs of advocates who are appearing that day. From there, you get the email ID and start to shoot emails. I think that would help. Plus, I think be on LinkedIn, and there are many opportunities to advertise there. That would help you. If somebody else wants to add, please go ahead.
Can you recommend a few advocates or firms where we should apply?
I think, Arjun, that is not the purview of this orientation. You are most welcome to contact one of us afterwards personally, and we'll be most happy to entertain those questions.
All right. Thank you so much.
Thank you. Yes, Sharik.
I want to ask you how much time we will get after the notification for the preparation.
as I said, it will be there in the notification. As for the sake of propriety of the process, I cannot divulge that information before it is out. So I would suggest that you please be a little patient, and once it is out, we'll be most happy to share it.
Okay, thank you, sir, very much.
Well, thank you so much, Uday, for posting the numbers of the EC members on the chat. You are most welcome to reach out to them in case you guys have any queries.
These numbers are also posted on the Facebook, so if you need any help, you can just.
No, please don't post these numbers on Facebook.
No, not on Facebook, the live chat.
Huh?
The live chat.
No, don't put these numbers on Facebook live chat.
Yeah, I'm gonna have to second Madhav on that.
Yeah, no, numbers don't go on Facebook live chat, no.
Actually, the point is that, I stopped the live stream.
Doesn't matter. That's okay. They can contact one of their friends and they can get our numbers, but no.
Okay.
Numbers are not going on Facebook.
Okay.
Moots do not have any verdicts. They only have winners and losers, and this was a demo. And in the spirit of the demo, we did not ask the judges to score our participants and our teams. All right. Prerna, I think we can end the meeting.
Yes, we can.
Perfect. All right. Thank you, guys.
Thank you, sirs and ma'am, for